But it was God's work towards, let me repeat that again. All creation then is seen by God as living in harmony and in peace with each other. We have a problem when we look at scripture in Genesis 3. When sin pierced and interrupted that ability to be able to live in shalom, we had a messed up paradigm of existence where some other aspects were entrenched, beginning to interfere with the aspect of the image of God, which is the question of rights. God's vision is to see a shalom setup for his people. If you skip with me all the way to the end of the scriptures, Genesis 21, verse 3 to 4, John records, "And I heard a loud voice from thy throne saying, Now the dwelling of God is with men, and they will live with them. They will be his people, and he himself will be their God. And he will wipe every tear from their eyes." What do you suspect some of these tears were brought about by? Infringement of human rights, causing tears. But God's vision is to bring harmony and shalom. And he says there at the end, there will be no more. I don't know when we'll get to that point. No more death, mourning, crying, pain, let me add, suffering, and everything you can, injustices. For the old order of things has passed away. That is in the distant future, what we are working towards. I read at the beginning, Exodus 3, 7 to 10, and I want you to keep this, that the fact that God said, "I have seen my people suffer," that narrative draws its context in Genesis 12 to chapter 50, where we have the narrative, where we have the birthing of the nation of Israel, from the life of Abraham, Isaac, Jacob, to the 12 sons of Jacob, who constitute the 12 nations of Israel. In the process, through Jacob's son, Joseph, the Israelites find themselves in Egypt, a foreign land. What happens in Egypt? Exodus 1. I just quote this. "Then a new king, who did not know about Joseph from the power he had, came to power in Egypt. Look," he said to his people, "the Israelites have become much more numerous for us. Come, let us deal with them shrewdly, or they will become even more numerous, and if war breaks out, they will join our enemies and fight against us." Now take note of verse 11. "So they put slave masters over them to oppress them with the forced labor. And they built a city called Pithom and Rameses as store cities for Pharaoh. But the more they were oppressed, the more they multiplied and spread." I don't know how that was happening in an oppressive setting, but they were increasing. "So the Egyptians came to dread the Israelites and worked them ruthlessly. They made their lives bitter and hard, with hard labor in brick and mortar, and with all kinds of work in the fields. And in all their hard labor, the Egyptians used them ruthlessly." Allow me to shortlist from that passage some of the social issues that were happening. For example, there was clear oppression taking place. There were injustices that were taking place. There was a lot of unfairness. There was intolerance. And we even seeing human dignity undermined. There are so many things we can take. And the Bible says there, it made their lives bitter and unbearable. Could the lives of Kenyans be bitter and unbearable in some way? As for you and as lawyers, and this conversation continues. But this infringement and undermining of human rights did not skip God's attention, as recorded in Exodus 3, 7, and 8. And I want you to capture this, because this will help you in your conversation. The Bible says, "And the Lord said, I have indeed seen the misery of my people in Egypt. I have heard them crying out because of their slaves, and I'm concerned." I want you to mark the three aspects. I have seen, I have heard, and I am concerned about their suffering. And I like the next one, verse 8. "So I have come down to rescue them from the hand of the Egyptians." God is here in this text presented as the champion of human rights. God is actually portrayed as championing and advocating human rights for his people, the Israelites. He wants them emancipated from oppression. He wants his people to experience freedom. I like the third one. He wants them to thrive. But the kind of human rights abuses that were taking place were threatening this possibility. And so God, and I close with that, God chose to engage human agency to and advocate for human rights. Exodus chapter 3 verse 9 to 10. And now the cry of the Israelites has reached me, and I have seen the way the Egyptians are oppressing them. So now go. Who is being addressed? Moses. You now become my agent. You are now going to be the one to carry the mandate. It is my business, but you are my agent. You are doing it on my behalf. I'm sending you to Pharaoh to bring out the people of the Israelites out of Egypt. As we celebrate this small book, which was put in place, the Constitution. As we think about it, I think the question of human agency must be at the core of our thinking. And so the call to go, Moses, now go, that call to go constitutes our mandate as advocates of human rights. We are going on behalf of God. Moses, you are going on my behalf. But the mandate has to be missional. Another word, it has to be mission-oriented. We have to be partaking with God, remembering that we are partnering with God in his endeavor to see human rights upheld. As I close, I say this viewpoint of the fact that we have been given a mandate as human agents is critical for informing, shaping, and anchoring our conversation around the areas of human rights. This could explain the gap that we are seeing in meeting the constitutional demands in our society. When we begin conversations that sideline the master human rights, the champion of human rights, then we skip a major gap on that. So let us not in any way sideline God's viewpoint. And let us not imagine that we can have a conversation on human rights, leaving the Creator who actually entrenched rights on humanity. He has to be at the center. And my prayer for this conversation, I think the moderator talked about foundations. I'm pushing harder beyond just the political-based foundations to the Creator himself. The foundations are not about what religion you believe in. The foundations are not what church you go. The foundation are that we are dealing with the image of the Creator, which is basically we are partnering with God to advocate for what he wanted to. And he himself says, I have seen, I have heard, and I'm now coming down. So may I encourage you that we don't have conversations around these seats. May we become the voice, the advocates, in the right way, in the areas where the Lord will place us. May he use you and use me for his glory. I was looking at this chapter 4 and running through it, and I thought there was a lot of theology. There was a lot of God in the way this was constructed. You cannot just think about human rights, freedoms, without having to think about where are we beginning. We are beginning with something entrenched within humanity. Whether I'm a Muslim, whether I'm a Hindu, whether I'm a Christian, whether I'm an atheist, if there's an angle to start is to begin to ask, where does this begin? And that can change our conversation. I'm not a prophet of doom, but I wonder whether Kenyans will get far with the Constitution if we leave God out of the conversation. Because he sets a clear direction. And that's why this conference is so critical for us. Even as we think about foundations, there's an underlying foundation that shapes our thinking. May this shape your thinking, and that we may become the Moses. So now, let us go and be the advocates. But we do that with God in mind. Let us pray. And so, Heavenly Father, we thank you so much for the grace we have this morning. Our constitution, the human constitution that belongs here to Kenya, has a lot of things that have been set for us that can help us to think about how God intends for us to influence and engage in matters human rights. I rejoice with this team for the conversation that started yesterday. And even as we were articulating issues on the foundations, what a way to think that even the fact we are created in the image of God in itself entrenches human rights or rights on us. And we pray that as we continue to pray for our nation and those who are spearheading every dimension of implementing our constitution, that we will remember God is in this. God is concerned. God is interested. He pains when he sees people experience injustices and pain and suffering that could be averted. It is our prayer that our conversation today will be rich with the revelations and the renewed strength and ideas and the insights that will guide us to become better. Would you help us, even as we have this conversation, we place ourselves in the hand of the Most High God that truly will benefit from this to the glory of your name. We pray in Jesus' name. Amen. Thank you.
Our next speaker is Mr. Cedric Katiba, a HOD here at the Kabarak University School of Law. He's an advocate of the High Court of Kenya and a scholar of wide-ranging interests in international law, dispute settlement and arbitration, regional integration, governance, and human rights. He holds a bachelor's degree from Kabarak University, a postgraduate diploma from the Kenya School of Law, and a diploma in WTO law from the Geneva Institute. Beyond his teaching and departmental leadership, Mr. Katiba is an active researcher and writer. His recent publications include a book chapter in a book recently launched, Harvesting Equality, looking at gender governance and stewardship, with this chapter looking at ecofeminism and agripreneurship. He's written on raising the minimum age of criminal responsibility in Kenya in the Kabarak Journal of Law and Ethics, contract and assignment of arbitration agreements in the African Journal of Commercial Law, and other contributions in the Nairobi Law Monthly, and other contributions in the Nairobi Law Monthly. He has been instrumental in shaping legal education and mentorship at Kabarak University, and was a founding member of the Avid Readers Forum at the law school, a vibrant student-led forum for scholarship and dialogue, and has played a key role in guiding students in international moot competitions, including the Nelson Mandela World Human Rights Moot Court competition. Please join me in welcoming Mr. Cedric Katiba.
Thank you, Sam. I must say, I've never known myself with all those things you've said today. I'm not even sure all of them are true. But lucky enough, Sam gave me an early warning. I told him, I don't have any profile to be introduced with. I just go by my two known names. Then the third one is also unknown to me. But that being said, I welcome you all to the second day of the conference. Happy to see your faces. I hope all of you are happy. I'll also try to speak in Swahili because I also come from the Western region, but I think the Swahili might be too difficult for you, so I'll just stick with English. So, nawakaribisha nyote. Karibuni. Jana tuliweza kuwa na kongamano ambayo ilienda vizuri sana. Tuliongelea mambo mengi kwa vikao tofauti tofauti ambavyo vilikuwa, na tuliweza kusikia pia kutoka kwa wanahistoria ambao wameishi kwa I think that's where my Swahili ends. Now I can proceed. The second thing, apart from the welcoming remarks, I'd want to talk about is that our constitution has undergone a lot of transformation, which is now the basis of our conference today and also tomorrow. And if you've been in the different sessions, at least you've gotten the different angles, different aspects of the transformation. And one thing I'm happy about is that Kabarak University, specifically Kabarak Law School, has been the center of the discussions of the transformation of the Constitution of Kenya. And we have had different moments which our Constitution has experienced in the last 15 years. For instance, there was a time in this republic where almost every Kenyan knew what Form 34A is. I'm not sure if any of you can remember it now. Can you remember what Form 34A is? But there was a time, even if you would meet somebody on the road, they would know what Form 34A is. It's because there was a moment in this country that litigation concerned the Constitution, and everyone knew that in a presidential election, we have Form 34A. There was also a time where everybody in this country knew what the basic structure is, or the conversation surrounding the basic structure. It's because in the last 15 years, we had a moment where we had to discuss what a basic structure doctrine is in this republic. Anybody, anywhere, in any village, could have told you what the basic structure is, or had an opinion on what the basic structure is. But right now, if you ask any law student what the basic structure is, I'm sure Mr. Ngure always gets very crazy and unprecedented answers. Recently, most people in our country knew about the famous Mandamano. Everybody knew about their political rights. Everybody knew about the right to assemble, demonstrate, and picket. They knew they had to be peaceful, whether or not it is contested. But at least we had moments where we could reflect on a provision of the Constitution and get alert to ourselves about it. And these have been the center of our discussion. There have also been moments whereby everybody knows the procedure of impeachment of a governor. There is moments whereby everybody had an opinion about the impeachment of the deputy president from office. At least everyone had an opinion on the procedure. And now, this conference, we are discussing about the Bill of Rights, and would like to hear your opinion. So in those different panels, we'd like to hear your opinions. Yesterday, we started with a discussion on the fundamental articles that support the Bill of Rights, and we proceeded briefly to civil rights. Today, I think the discussion now advances even further to political rights, economic rights, social rights, cultural rights, rights of special interest groups such as women, children, persons with disabilities. I don't know if you know, older people are part of the special interest groups in the Constitution. Wazee ambao mko hapa, mnajua kwamba katiba inawa shughulikia? Mnajua kweli? Even the youth, do you know that the youth are actually part of special interest groups? Youth, mnajua? Vijana. That you're actually supposed to be accorded as special protection, some special treatment from the Constitution. I don't know if this is still the case 15 years later after promulgation of the Constitution. I think back then, the youth felt that they were not involved. Right now, it is the youth participating in governance directly. The youth can tell the government or can tell the president, do not sign this bill, and the president will not sign it. I don't know if this was the case 15 years ago or 20 years ago. Are the youth still qualified to be part of the special interest groups? We don't know. Maybe have they involved? What happens if the youth overpower the old men and old women in governance? Will they still remain to be part of the special interest groups? We don't know. Anyway, as a precursor to this conference, the Avid Readers Forum, where I now head, we had very interesting discussions surrounding all this group of rights. And now, to this conference, we are now gathering all the experts, all the members of the community, all the authors, now to discuss the progress, prospects, and basically what could be done differently. So I just take this opportunity to welcome you all to today's discussion. I must also emphasize that this discussion contributes towards what is called eternal vigilance to implement these provisions of the Constitution. And I'm glad that the speaker who will just come right after me to give the keynote address, Dr. Gautam Bhatia from India, is one of the ever vigilant people on matters concerning the Constitution of Kenya 2010. In fact, all these momentous activities, the last 10, 15 years, he's been able to comment on it, write on them, speak on them. I think he has even come here physically at Kabarak at the Avid Readers Forum at one point in time to speak on these issues, to discuss on these issues, to sensitize on these issues, to criticize on these issues. So today just serves another platform to extend this eternal vigilance that we must have to implement our Constitution effectively. I think that marks the end of my welcoming remarks. Karibuni nyote, tena, and welcome. I think if you have any concern, you can just look for me out there, then we can sort it out, be it tea related, be it lunch related. I'll be able to help. Karibuni.
Our keynote address will be delivered by Dr. Gautam Bhatia, who is an adjunct professor at the Jindal Global Law School. Dr. Bhatia is a renowned Indian constitutional law scholar, legal practitioner, and science fiction author. He currently teaches law at the Jindal Global Law School and is celebrated for his interdisciplinary approach that fuses legal theory with speculative fiction. Born in New Delhi to a mathematician father and a documentary filmmaker mother, Bhatia pursued his legal education with distinction. He earned his BA LLB from the National Law School of India University in 2011, followed by an BCL and MPhil from the University of Oxford as a Rhodes Scholar. He later completed an LLM in constitutional law at Yale University in 2014. He successfully defended his doctoral thesis at Oxford in 2021. His scholarly contributions include the critically acclaimed The Transformative Constitution, a radical biography of 9 acts 2019, which was shortlisted for the Hindu Literary Prize, and praised for its incisive analysis of Indian constitutional law. He has also authored Offend, Shock, and Disturb, Freedom of Speech under the Indian Constitution, and contributed chapters in the Oxford Handbook of Indian Law and the Oxford Handbook on the Freedom of Speech. Dr. Bhatia has also played a legal role in landmark constitutional cases, including those involving criminal defamation, privacy rights, Section 377, decriminalization of homosexuality in India, and other biometric identification. In the realm of fiction, Bhatia debuted with The Wall in 2020, followed by its sequel, The Horizon, in 2021, both set in the dystopian fictional city of Sumer. These novels explore themes of freedom, identity, and social hierarchy, and have been praised for their imaginate world building and political allegory. His latest novel, The Sentence, continues this tradition of speculative storytelling. As a coordinating editor for Strange Horizons, a leading speculative fiction magazine, Bhatia has helped elevate the genre in India and globally. His work, both legal and literary, reflects a commitment to contestatory democracy, intellectual rigor, and creative engagement with pressing social issues. I'm also aware that Dr. Bhatia has recently released his new book, Transformative Constitutionalism and Kenya, and has been amicus curiae in the Supreme Court case revolving around the basic structure doctrine in 2020. And so, with that introduction, please join me in warmly welcoming Dr. Gautam Bhatia as he gives today's keynote speech. Dr. Bhatia, are you with us? He's joining us
Yes,
online.
yes. Am I audible?
Yes, you are. Please go on.
Thank you. Thank you. Thank you so much for inviting me to deliver this keynote address. It's a great honor and a great privilege, especially as a non-Kenyan who is engaged with the Kenyan Constitution over the last many, many years. This is indeed a great privilege. And as a comparative constitutional scholar, as a comparative constitutional lawyer, I'm always very excited when there is a new judgment by the Kenyan courts on constitutional law in the offing, because I know that it will be a great learning experience. I'm going to learn something new. And that's always been the case over the last many years. Both when I agree or I disagree with a judgment, I always learn something new from the Kenyan courts and my colleagues at the Kenyan bar. And so it is in that spirit that I want to deliver these opening remarks in this keynote address. So when we speak about transformative constitutionalism, or the idea of transformative constitutionalism in constitutions across the world, we normally think of it in three ways or three forms of transformation. The first, of course, is political transformation or politically transformative constitutions that emerge at the end of a liberation struggle or a struggle against authoritarian rule and seek to invert the relationship between the rulers and the ruled, from subjects and rulers to citizens and accountable administrators. So the structures of government, separation of powers, and those kinds of ideas speak to political transformation. Then there is comprehensive transformation or comprehensively transformative constitutions that also interrogate not just political structures, but also social hierarchies, hierarchies within the private sphere, inequalities that go beyond the state and the public sphere. So that is comprehensive transformative constitutionalism. And then finally, there is what I call deep transformation, which is a fundamental interrogation of the power map, which is a term that Gifu Mugai has used in his book on the Kenyan Constitution, interrogates the power map or the structures of power that inform and structure society. And if you look at the last 15 years, if you look at the framing of the Kenyan Constitution and its interpretation, you will see elements of all three kinds of transformation in the cases and in the judgments of the courts, and that's what I'll reflect on briefly in these remarks. Now, there are many different perhaps to speak about some of the lesser discussed judgments. So, of course, we have the famous judgments, for example, Mitubel, which have been analyzed and discussed a lot. I thought I'd perhaps just talk a little bit about some of the lesser discussed but equally important transformative judgments that have been handed down over the last 15 years or so. And I thought I would just begin with investigating, like I said, in the context of comprehensive transformation, this idea of the private sphere and inequalities within the private sphere, within the domestic sphere, and the family. And in this context, to begin with a very interesting 2021 judgment in MW versus AN, which was the High Court at Kuru, where the High Court stipulated that the performance of housework and care work by the female spouse within the home resulted in entitlement to shares of property upon the dissolution of the marriage. And this judgment was based upon the core idea that the kind of work, care work and domestic work that goes into maintaining the house is as much worthy of remuneration and as much worthy of equal respect and dignity as is employment in the public sphere. And on that basis, the High Court held that even though it is in our society the less, and I'm using the High Court's words, the less obvious contribution, it is nonetheless unfair and unjust for one party to be busy just making their money, the seen income, while the other is doing 2 or 3 other jobs in the family whose income is unseen, and then claim that this other one did nothing. And so, on that basis, the High Court delivered its judgment. And this, I would say, was a very subtle and sensitive exploration of entrenched inequalities within family structures, and a call to ensure that primarily gendered tasks, such as housework and care work, are not economically marginalized as they have always been, something that in turn has always disempowered and trapped women within oppressive family structures. In fact, coming at this from a lens of a comparative constitutional lawyer, the High Court's judgment was strikingly similar to an earlier judgment of the Colombian Constitutional Court, which had recognized a widow's legal interest in a home based on her non-monetary contributions. The Colombian Constitutional Court in that case had noted, in particular, how invisibilizing domestic work and creating artificial distinctions between productive and non-productive work had the effect of deepening social and gender inequalities. And many years later, then, of course, Matheka J, in this case, took up the same logic and developed it in greater detail within the context of the 2010 Constitution. 2 years after, in Ogentoto versus Ogentoto, the Supreme Court adopted a similar formulation, even as it continued to reject a call to establish a 50% rule as the presumptive default position. The Supreme Court noted the existence of a general assumption that parties to a marriage contribute towards the home and the family in one way or another. While this recognition is important, the court's judgment also reflected an unease with the full working out of this transformative logic, as it noted that equality within marriage did not necessarily entail redistribution of property. But to me, it's hard to see how a transition from previous inequality to present day equality would not entail redistribution in some form. So, as with the Mitubel case in the context of evictions and housing, we see something of a hesitation within the court to fully interrogate unequal social structures. So there is interrogation to an extent, but what we can see is both the potential but also the limits of transformative constitutionalism when we litigate such cases in courts. Now, sticking with the theme of private power structures and equality, in July 2023, the Court of Appeal, in a fascinating judgment, extended the logic of transformative constitutionalism into the domain of consumer rights. Nairobi Bottlers Limited was found to violate the constitution when it provided different nutritional information on glass Coca-Cola bottles and plastic bottles. Other than the fact that Nairobi Bottlers Limited was a private company, and thus this was a case of horizontal rights, that's rights between private parties, where again the Kenyan constitution is a trailblazer, as are the judgments of the Kenyan courts. This decision is significant as well because the basis of the discrimination was the purchasing power of those who bought plastic bottles vis-a-vis those who bought glass bottles, of course, in a generalized sense. In other words, the basis was economic class, a ground that constitutions have been very careful to exclude from their non-discrimination provisions, because doing so would, of course, interrogate the very structure of the political economy that creates poverty and class, as we know. And thus, the Court of Appeal in this judgment laid the groundwork for an evolving jurisprudence of subjecting class-based inequalities to the Kenyan Constitution's non-discrimination clause. And it will be fascinating to see how much further the courts can take this jurisprudence in the future. Indeed, discrimination and inequality, unsurprisingly, have been litigated frequently under the 2010 Constitution. The Kenyan courts have often faced claims from religious minorities in relation to uniform dress codes or other such rules, which have been framed keeping in mind the default ways of living of the cultural majority. By and large, in my view, in my reading, and especially as compared to other countries, including my own country, India, the Kenyan courts have been responsive to these claims. For example, in Skolin Anyango Ojunga versus HealthLink Matker, a Seventh-day Adventist was sacked from her workplace because she asked for a day off on Saturday in accordance with her religious beliefs. The Employment and Labor Relations Court held this to be unconstitutional, as the employer had failed to provide their employee with the reasonable accommodation that the Constitution's equality and religious freedom clauses required. Similar principles were followed by the Court of Appeal in affirming the right of Jehovah's Witnesses to not attend Catholic Mass at school and the rights of Muslim students to wear a hijab. In all these judgments, what has stood out is the court's willingness to affirm the social diversity and pluralism does not end at the doorstep of the workplace or the school. Rather, as microcosms of the larger society, the workplace and the school are where diversity and pluralism should be celebrated instead of being coddled into a culturally dominant understanding of uniformity. Furthermore, an understanding structural imperatives in the absence of genuine choices in these cases, the courts have given short shrift to the if you don't like it, go somewhere else argument. And that has actually resulted in the crafting of a powerful and persuasive jurisprudence of equality. In the same context, if there is one domain where perhaps we can see the limitations to an extent of transformative constitutionalism, it is that of the rights of sexual minorities. So, of course, in EG versus Attorney General, the High Court declined to strike down a law criminalizing same-sex relations. It deployed a familiar logic, which is familiar from across courts in different jurisdictions, that what the provision punished was acts and not individuals. And it invoked the fear that decriminalization would open the door towards civil unions and marriage. The court's analysis here was in striking contrast to the more subtle and nuanced anti-discrimination jurisprudence that the Kenyan courts have otherwise evoked in the context of minority claims. For example, the effects-based test or the purposive interpretation to the open-ended grounds of discrimination that Article 27 sets out. Now, of course, a redressal of some kind arrived in 2023 when a very closely divided Supreme Court upheld the rights of LGBTQ plus persons to associate and struck down the refusal of the state to recognize an NGO that advanced the rights of queer persons. This brought to an end a decade-long battle for recognition that had passed through the High Court and the Court of Appeal. And so, in this case specifically, the Supreme Court's finding that the term sexual orientation could be read into the word sex under Article 27 at least opened the door for future developments in this domain. And again, much of this, as in other cases, the roads are still very much, there are two possible roads that the court can travel down on in the future. Now, this somewhat uneven evolution of transformative jurisprudence is something that Professor Ambani himself has traced in the evolution of many of these provisions in the Bill of Rights to the requirement that a new constitution must be ratified through a referendum, which was introduced in the Najoya case, and the consequent shadow of majoritarian politics, within which certain issues in the new constitution turned particularly contentious. Professor Ambani, in his book, has noted that the wordings of Articles 26, Clause 2 and Clause 4 with respect to abortion, a definition of marriage, and so on, will remain testament to that contestation that has gone on both in the framing of the Constitution and in subsequent interpretation of it. And so, therefore, we must acknowledge that in many cases, transformative evolution of constitutions takes place in the interstices of provisions like these, and adjudication often has to work towards harmonizing these various jarring notes by resolving textual ambiguities in light of the Bill of Rights' overarching transformative vision. And it remains to be seen whether and how this will happen in the future. That apart, there are other provisions in the Bill of Rights that have been pressed into the service of transformative constitutionalism in very creative and innovative ways. In Constitutional Petition number E052 of 2023, the Employment and Labor Relations Court was faced with a familiar problem. A multinational corporation, in this case Meta, trying to avoid national labor law obligations by outsourcing work to contractors and contractual workers. Now, while this case may appear to be a pure labor law case, the court anchored its analysis within Article 41, which sets out a constitutional right to fair labor practices. This gave the court constitutional ballast for holding that cleverly drafted contractual arrangements entered into between deeply unequal parties could not be used to circumvent labor rights. The court could go, and indeed did go, behind these arrangements to discern who was exercising actual control over the digital workspace, and thereby the principal employer. To no one's surprise, it was Meta. The court's remedy is also important, as this case concerned content moderators, and the court specifically recognized the harms to mental health caused by content moderation. In fact, it extracted the affidavits of content moderators that set out in stark terms the nature of the tasks that they had to undertake and the trauma they suffered as a result. Meta's attempts to get around this by providing wellness counseling was rightly rejected, and the court directed the provisions of appropriate mental health support to the workers. The judgment, therefore, is crucial for at least two reasons: the recognition of mental health obligations of digital employers, but also the constitutional encasement of labor rights in the era of the online gig economy. It will be interesting to see if in future the court employs similar logic when the inevitable litigation around the labor rights of platform workers comes up before it. A second example is the judgment of the Mombasa Court of Appeal in National Environment Management Authority versus Kelvin Musyoka. The villagers of Ovino Uru had waged a long battle against the poisoning of their environment and their lungs by the processing of toxic lead in their vicinity. While it was admitted that the villagers' rights to health and a clean environment had been breached, the question was who bore the liability between the landowner, the factory owner, the regulatory agencies, and the city council. Recognizing that the environmental pollution was caused by the connivance of private operators and the state, the court noted that the state as an economic operator in the process of regulation and development of economic policies is well recognized, and the state and state agencies also engage in economic activities as operators. Drawing upon Article 69 of the Constitution, which requires the state to engage in preventive and proactive measures with respect to environmental protection, the court found that a failure of regulation and a failure of the state to erect and maintain regulatory legal structures was a breach of the state's obligation under the Constitution. This judgment is therefore crucial in recognition that pollution is embedded within a political economy where both the state and the private actors are intimately involved. And therefore, what needs to be done is to fashion a structural remedy to deal with the issue. In this case, monetary compensation and reporting requirements for the cleanup. Um, this judgment is also crucial in that it rejected the argument that pollution was somehow necessary for development and that therefore a balance must be struck between the two. Because what the court correctly noted was that the Constitution already strikes that balance in its existing language, and therefore there is no question of any extra constitutional consideration or justification. It'll again be important to see how this logic is deployed in future environmental cases. And what of public and police power? The kind of power that had been most abused and abused again and again under the old constitution of Kenya. Indeed, as late as 2023, the courts were still dealing with the fallout from the authoritarian period. Thus, in Wambere versus Attorney General, the Supreme Court considered a 30-year-old case of state violence against a group of protesters known as the Mothers of Political Prisoners. Disagreeing with the High Court and the Court of Appeal's holding that there had been too much delay in bringing the case to court, the Supreme Court highlighted the ongoing need for society to confront the wrongdoings from its past. Transitional justice thus could not have a fixed end date. It was in the very nature of transitions that there would be occurring and reoccurring attempts at justice and the retrieval of historical memory in order to achieve it. In fact, in a striking moment of self-awareness, the court acknowledged the failure of judicial institutions in ensuring that justice in the pre-2010 era was served, before going on to note, and I quote, to us, a judicial trial serves to send a strong expression of formal disapproval of gross abuse of human rights. It also functions to recommit state institutions and persuade citizens of the importance of human rights in a polity. On the other hand, failure to ensure access to justice could send the wrong signal that judicial imprimatur has been given to these historical wrongs. Such a stance will encourage and not deter potential violators of rights. It also sends the signal to the public that they can be complicit in violation of rights without consequences attaching to the perpetration of such atrocities. That's the end of the quote. And I think in light of recent events, such lines serve as even more powerful reminders of the importance of recommitting state institutions and the public to a culture of respecting civil rights. So transformative constitutionalism and transitional justice are therefore intimately entwined, as they require both a backward-looking view into the past as well a forward-looking view that involved a continuous recommitment by everyone towards the goal of transformation. One of the famous Kenyan writers, Mukoma Wagugi, once wrote in one of his novels, it hurts to remember, but it's worse to heal. But that is, of course, what is required in these cases of transformative and transitional justice. Of course, ensuring justice for the past has little meaning if its lessons are not internalized in the present. So, for example, in Anthony Njenga Mabuti versus Attorney General, the High Court was faced with one of those legal constructs that had been a staple of the colonial regime and had then been gleefully put to use by the post-colonial state. A set of provisions in the criminal code authorized magistrates to demand peace bonds from individuals upon being informed by the police that the said individuals were likely to commit a breach of the peace or disturb public tranquility, or certain variants of this formulation. A failure to execute this bond would lead to imprisonment. Now, the case was brought to court by individuals who had been compelled to execute these bonds. One of them had been in jail after being unable to do so, despite never being accused, charged, or convicted for any offense, but rather only because the police believed they were likely to commit an offense in the future. The state defended these provisions by pointing to their hoary roots in English common law and their continuance in jurisprudence such as Canada and so on. The High Court was having none of it, pointing on the one hand to the constitutional safeguards for those accused of offences and facing trial. Justice Mumbi Ngugi asked how legislation could create a class that is somewhere in the void, against whom no evidence has been found, and yet they are subjected to a process which must be conducted as nearly as the manner in conducting trials in criminal cases, but for whom no constitutional safeguards are provided. The state tried to dodge this question by a simple but familiar linguistic trick. People subjected to the peace bond, it argued, were neither accused nor arrested, but were simply suspects. As such, they were not entitled to constitutional safeguards, which were available only to the accused and the arrested. But transformative constitutionalism does not allow the state to deprive people of their rights simply by classifying them out of it. Thus, the Honorable Judge immediately asked, by way of response, and I quote, "Who or what is a suspect? What is its place within our new constitutional dispensation based on human rights, non discrimination, and the rule of law?" In other words, it was existing law that must be leveled up to comply with the Constitution, instead of the Constitution being leveled down to comply with the existing criminal code. And as the judge recognized, what mattered to the Constitution was not whether an individual was classified as an accused or a suspect, but by the manner and form in which coercive state power was being exercised against the individual. Again, in light of recent events, a very, very important thing to note. And so, therefore, the judge held that the peace bond provisions were arbitrary, unconstitutional, and discriminatory, because, as the judge noted, the peace bond provisions targeted the poor, those who are perceived to be in the lower echelons of society, and therefore more likely to commit crimes. Likely. Almost invariably, the targets are poor young men who have not been tried and found guilty of any crime. I'll close the quotes. So this, for me, is really an exemplar of how transformative constitutionalism works and works through these kinds of analysis of the way in which state power, coercive state power, applies, operating against the individual. Now, I don't want to only speak about constitutional courts, because it is not only constitutional courts that have been engaged in this process of transformative interpretation. Now, we often say across the world, in the common law world, that the first line of defense of fundamental rights is the magistrate, the first judge who will assess or hear your case. And far too often, that is where we find that the protection of civil rights is a little lacking. That has not been the case often in Kenya, and one example is a Directorate of Criminal Investigations versus Calvin Okoth Otieno, where the police arrested certain protesters and asked the court for 10 days custody in order to complete their investigation. The police spiced up their request, as they often do, with claiming a larger conspiracy that had been afoot and had been nipped in the bud. But the senior principal magistrate, Honorable M.A. Opondo, gave this very short shrift. Relying upon constitutional jurisprudence, she began by noting that the acontextual and simplistic pitting of public order, peace, and security against personal liberty is a dangerous anti-liberty ethos, which was rejected by the Constitution of Kenya. It is dangerous in particular because at the stage of remand, where nothing has yet been proven against an individual, this ethos exempts the state from its duty of maintaining law and order and instead places that duty upon the accused shoulders by keeping them in further custody. And applying this doctrine, the Honorable Magistrate noted that the state's claims of conspiracy rested entirely on unproven and undemonstrated assumptions. She therefore applied the well known constitutional doctrine of proportionality and asked whether the state had managed to prove that depriving the accused individuals of their liberty was the least restrictive measure available to it. On facts, the state had failed to do so, and therefore the request for custody was unfounded. This order is perhaps one of the most striking examples of a genuine commitment to transformative constitutionalism. And I know that on this remand issue, the orders of the courts have been in Kenya inconsistent like in any other country. But this order is what I want to focus on because this, like I said, is one of the most striking examples of a genuine commitment to transformative constitutionalism. Because what it does is that it correctly notes, correctly understands that detention without trial was one of the most frequently used weapons in the colonial state's armory, no matter which the colony, Kenya, India, you name it. Upon independence, a lot of states, from India to Kenya, adopted this kind of detention without trial as a part of post-colonial armory to be used against their own people. So, of course, in Kenya, one of Jomo Kenyatta's amendments specifically concerned detention without trial, to the extent where this kind of detention becomes completely normalized. And in that context, the Honorable Magistrate's order sets the court's face against such normalization of state power. In a sense, it gives life to the oft-quoted platitude that in a transformative constitutional order, one day without liberty is one day too many. So, in conclusion, the examples I have talked about provide but a flavor of the many and diverse issues that the Kenyan courts have grappled with in 15 years of working a transformative constitution. From adjudicating on the validity of a national biometric ID scheme, the NIMS Huduma number, to evolving a jurisprudence of fourth branch institutions, from grappling with how to make public participation a reality, to ruling on free speech and criminal defamation, there is enough in these first 15 years for a lifetime of conversation, and these remarks are but one tiny contribution to that conversation. Above all else, what we must remember is that the Constitution is a terrain of contestation. The transformative vision is a vision that is not guaranteed, but must be struggled for. Like any other human creation, the 2010 Constitution is a crooked timber, a document with its own tensions and contradictions. As the legendary late Kenyan writer Binyavanga Wainaina once wrote, we don't question each other's contradictions, we all have them. Transformative constitutionalism asks us to hold these contradictions in balance and move forward nonetheless. The 2010 Constitution of Kenya has had quite the journey so far in the first 15 years. And in the coming times, there is no doubt that it's a journey that will continue to surprise, to delight, to inspire, sometimes to disappoint, but always to provoke, stimulate, and challenge. Like all transformative attempts, it is upon a bridge between the past and the future, and always looking towards the horizon that is to come. So with that, I will close these remarks. Thank you very much once again for inviting me to speak. And it is always a great privilege and a great honor. Thank you very much.
Thank you very much, Dr. Bhatia. I am wondering whether you have 5 or so minutes for questions or you have to leave.
We can do five. We can do. We can go up till. It's. Yeah. Sorry. What's the time? Yeah. Until the next 7 minutes. Yeah. Until 10 to the clock. Yeah.
Okay, excellent. Any questions that you'd like to have to Mr. Bhatia? I can see Lewis has immediately put up his hand. Somebody get him the microphone. Anyone else? Okay, let's remember the rules. Keep it short and precise.
Good morning. Thank you so much, Dr. Bhatia. My name is Lewis, a student here at Kabarak. So my question will be, your conclusion was perfect, that we, as persons, we have our tensions and contradictions, and they are evident in our transformative constitutionalism. So my tension and contradiction would be with regards to the tensions that courts have when dealing with contentious matters. So for instance, whenever we have a political question or questions of sexual minorities, which are very contentious issues here in Kenya. So we find a certain type of deference from our judiciary. So is there a balance that our courts can strike so that they don't necessarily have to ruffle any feathers, but at the same time don't get to stifle the promise of transformation that our constitution provides? Thank you.
Okay, I think you can take one more question for Dr. Bhatia. Anyone with a question about protests? Please, on Sase. Yes.
Good morning. My name is Onsase Precious, and I think I'd like to reiterate the conclusion that he has made, that the Constitution has its ruffles and bends. And my question would be, therefore, that even as we look at it from this angle and as we're looking at its progression, do you think that we can reach a point in our lawmaking systems that we establish a constitution, or rather a guiding principle or law, that is less of the bends that we see and more of an order of sorts, that we reach a point in our constitution making that's not necessarily achieving perfection, but achieving something closer to it? Do you think that is possible? Thank you.
Okay, Dr. Bhatia, maybe you can tackle those two questions.
I mean, thank you for these two wonderful questions, and they're both closely, I think, related to each other. So on the role of courts when adjudicating contentious issues, now that's a massive challenge, and it's something that courts across the world grapple with all the time. And in my experience, both as a constitutional practitioner who's often been involved in these kinds of contentious cases, a lot of action actually takes place outside of the courtroom, because judges are motivated by many reasons, and one of those reasons is always institutional self-preservation, right? And those of you who have read constitutional history across the world, for example, you are aware that the US Supreme Court used to repeatedly strike down welfare legislation in the US for 20 years, up to a point where Roosevelt finally had to threaten that, I'm going to pack the court, I'm going to expand the court. And then finally, out of self-preservation, they turned, right? But it was the political process that finally prompted them to turn. So institutional self-preservation is one of the major factors that guide judges in deciding how far they can go. And normally what I've noticed is that judges are able to often nudge public opinion forward. They're able to, go a little ahead of the curve if they want to, and if they are inclined to. But normally it's beyond roughly 10 degrees of where the, what in their perception, where public opinion is, they normally don't go beyond that because of concerns of self-preservation. And of course, judges come from society, so they themselves share, the way society looks at various things, or at least the dominant part of it. And so I think that when you're looking for transformative or otherwise progressive rights protecting resolutions to these kinds of contentious cases, it is crucial that a large part of the work be done outside of courts through social movements, through public movements, and of course, the people's role is set out very clearly in the Kenyan constitution. And once that is done, but the laws have not yet kept up, the laws are still archaic, then often the court will find it easier to perform that last role and strike down the law, just sort of protect rights. But the essential work to get to a point where it is possible for a court to protect rights is often outside of the courtroom. So, again, if you read history, global history, the entire civil rights movement in the US, for example, for all its failures and flaws, the courts sort of follow it, right? The courts, once there is the movement, then the courts can come in. But the courts cannot create the movement, and the courts cannot advance, or like the courts cannot, in advance issue rulings that are there. So I would say that to answer the question, it has to be a combination of mass movements for justice, for rights, and building a certain kind of rights protecting atmosphere in society, which then, once that's done, the courts can step in and do the legal task of protecting rights. It's much harder to reverse that. In fact, I'd say it's almost impossible to reverse that, right? So if you look at the Kenyan decisions, it is the legacy of public participation in constitution making that the courts are now protecting. But you have to have had that 20 years of public participation, which then becomes the historical legacy that the courts protect. So it goes in that flow. On the second question, on the bends versus the orders, so I think that any society that is pluralistic and diverse will always have disagreements about the best ways of living together. And in many ways, those disagreements will always be there, and they're not always a bad thing, except where, in the words of James Baldwin, the disagreement is rooted in denying someone's right to a dignified existence, in equal existence. The denial could come via the state, it could come via the political economy that creates a situation of social murder and so on. And so I think those kinds of conflicts which are rooted in more powerful people denying the existence or the rights to existence of the less powerful, that is something that you need the Constitution to resolve in a just way and to transform those relations, break down hierarchies and create equality, along with the mass movements. But the other kind of disagreement, which is more of more a function of our individual diverse worldviews, I think the Constitution need not try to smoothen those things, because I think at some level you need to have a society which does have those what you very eloquently called bends. I think it actually, you don't want a society which is completely smoothened over. Like, you also want those bends, as long as you're not harming someone, or as long as you're not creating a culture of impunity. So I think it's a balance between those two, is what I would say.
Excellent, Dr. Bhatia. I think you have to go, or do you have time for one more?
Yeah, sorry. So to have a next appointment. But again, my gratitude and thank you so much for inviting me to speak.
Okay, excellent. Thank you so much, Dr. Bhatia. As you've heard, he has highlighted how the courts have worked towards seeing the promise of the Bill of Rights fulfilled. And he has highlighted how courts work in the interstices, in the spaces that are left by law. So places where the law is unable to fill, or where the law has not caught up with a very progressive constitution and a very progressive Bill of Rights. The courts have been able to step in to say that the state cannot take advantage of these old laws that were very pro-state to take advantage or to abrogate or to harm ordinary people's rights. Whether you've seen, and you've also seen that he has highlighted how the courts have used the Bill of Rights to also protect citizens from transgressions of rights done by private persons. So in the Nairobi Bottlers case, in the cases of mining in the coasts, he has highlighted how there's been this horizontal application of human rights that is quite innovative by our courts, and to the point where they can tie the state as a regulator for failing to regulate a private person who is having somebody else's rights. So for example, in that NEMA case in the coasts, where they were unable or they colluded with a private operator to not look at the way the private operator was polluting the environment to the harm of others. I also love the way that he has looked at criminal trials and even the work of lesser courts like magistrates' courts to to use the Bill of Rights to protect the rights of accused persons and the dignity of accused persons, not to treat them as already convicted and therefore liable to being held without some semblance of when it is that the case against them might start, and to stop the state from using arrests of a person as a punishment, because the state has a way of trying to intimidate or to silence dissenting voices by just using the arrests without any intention whatsoever to prosecute. So I love that he has looked at all of these different aspects and given us a very good overview of how we shall continue with the discussions in the afternoon today, even as we deal with political rights, as we deal with the rights of arrested persons, as we look at labor relations, as we look at the Fair Administrative Actions Act, and the right to fair administration in the rest of the sessions later this morning and in the afternoon. Okay? So please give him another round of applause. I also want to recognize certain organizations that have joined us today, including Speak Kenya, Amnesty International, Kituo cha Sheria, the Center for Transformational Leadership, Midrift Hurinet, Nakuru Human Rights Defenders, CEDGG, NASCOF, the Nakuru County Civil Society Organization Forum, the National Legal Aid Service, Reshape CBO Nakuru, and also other community groups that have joined us. So there's the Atenai group, the Namtanyi group, the Makongeni Genesis group, Barina group, Hope in Life, Baraka group, Chepkonen group, Emmanuel B group, Playmakers, Abasera Women group, Upendo Women group, Creative Women group, Credible Investments, Turkomoi group, Pamoja, and Maji Avenue group. Please give them a round of applause for joining us. You're most welcome. So for now, our program now goes to a short tea break. It's 10:56, so we will break until 11:30, and then we shall join back in 3 breakout rooms. The first breakout room, which will be in Katiba Auditorium, which is the auditorium across, will be dealing with Article 38, which is the right on political rights, Article 39, the freedom of movement and residence, Article 40, the right to property, and Article 41, labor relations, and it will be moderated by the lead discussant, Mr. Samuel Kimeu, the Executive Director from Africa's Voices. The second breakout room, which shall be here at the Sawia Auditorium, will be led by Dr. Rosemary Mwanza, who is our former colleague here at Kabarak Law School, but right now is a research fellow at the University of Stockholm. She'll be joining online. and it deals with various socioeconomic and community rights. So it will be dealing with environment, language and culture, the right to family, consumer rights. Then the third breakout room, which shall be held in the moot court upstairs on the other side, will be dealing with the fair administrative action, access to justice, the rights of arrested persons, fair hearing. So this shall be led by Mr. Ibrahim Alubala, who is right here with us, a colleague, and also an African director at the Save the Children organization. He's a human rights and child rights governance advisor. Excellent. So we break for tea. Thank you for all of us who are joining online. There shall be various links. So the link to breakout room 2 is the link that has been started for this meeting, the webinar, and there'll be 2 other meeting links that shall be sent for the other 2 rooms. So if you want to join us online, either in breakout room 1, dealing with political rights up to labor relations, or in breakout room 3, dealing with fair administrative action and to the rights of arrested persons and to a fair hearing, there shall be various links sent to you, and we hope that you shall be able to join us in any of those rooms. Thank you, and enjoy the short break up to 11:30.